I will be surprised if 30 days from now she hasn't decided. If I had to pick one winner, an outright win, SEC or Ripple, I would pick Ripple. Unopposed. A lot of people don't agree with me, but I'd pick Ripple because the SEC's theory is too overbroad.
In today's video, attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
You know, there were some predictions, and nobody can, of course, no one here is Nostradamus. So, some were predicting we could hear back from the judge by the end of March. But what's the timeline, as far as the window for when we may hear back from the judge in the Ripple case?
Yeah, listen, I got a little mad at somebody. Well, not mad, but like I got defensive for my friends, right? You make an educated guess on when a decision would come down. And so there was this thought that it should come down around the end of March 31st, whatever. And we did get the Daubert motion, which is March 6th. So the reality is, if you look at previous cases by Judge Torres, then there's been an occasion where she ruled the Daubert motion on experts came down, and an hour later, the decision on summary judgment came down. And then there was a case where it was 2 weeks between. And then there was a case when it was 30 days between. And then there was a case when it was 60 days, right? So what I've been telling people is that somewhere between March 6th and May 6th, we'll get the ruling, right? It could be today while we're talking, it could be filed, or it could be May 6th. Now, is it possible that it could go to June 1st? It's possible, right? We don't know. All we can do is say, if you look at her previous cases, this is the general timeline for the summary judgment decision. But people also got to understand, as each day passes, doesn't it sound like this case has even more of a potential impact? Right? So for example, you've got Ripple filing those letters saying to her, look, this is what the Supreme Court said on a fair notice issue on one. And then there was another one where it said, look, this is what the judge in Voyager said about the SEC and the lack of clarity and all that. And so, maybe she's adopting some of that stuff. I don't know, right? Maybe her decision is 7/8 of the way written. And she's just, doing a few details. Maybe she's only halfway through. I mean, I'm just guessing, and all we could do is I will be surprised if 30 days from now she hasn't decided. I would be genuinely surprised. I would be slightly surprised if we are, if she doesn't rule by the end of the first week of April.
What do you think the outcome might be?
I think that the SEC loses summary judgment the way they asked for it. They asked for her to say that a past sale, present sale, and future sale of XRP is a security. They've asked her to say that XRP represents an investment contract with Ripple. I think that she rejects that. I don't think she's going to accept Ripple's argument on the blue skies, pre-1933 case law. I think it's a great argument by Ripple. I told everybody the day it came out, it was brilliant and I hated it, right? It was like this appellate brief. And I think it has meat on the bone as it relates to the Second Circuit and the Supreme Court. But at her level, where she says there must be a contract in order for an investment contract, I think they're going to lose that argument with her. I hope I'm wrong. It's a good argument. But there are too many other judges who said, and if you read the Supreme Court decision, it says a contract, transaction, or scheme, right? So it says contract, transaction, or scheme. Doesn't say and. So it could be I think the judge is going to read it like that because other judges have. I think that the real question is the SEC didn't give a lot of specific examples. So if I had to pick one winner, if you said who's going to win SEC, an outright win, SEC or Ripple, I would pick Ripple. Unopposed. A lot of people don't agree with me, but I'd pick Ripple because the SEC's theory is too overbroad.
Right.
And the SEC, when you read their summary judgment, they gave a few examples. They said in 2014, Ripple sent a brochure about XRP to about 100 people. She could find that to be what's called an offering. See, some people only think about the sales, but the law is you can have an unregistered security offering without a sale.
Interesting.
So that's an example where she could split the baby and say in 2014, that specific instance was an unregistered offering, and therefore that constitutes a violation. And then the question would be, does it go to like the fair notice and all that? And so my fear, Tony, is that it's going to be a jury trial on something. Right? That's my fear. Meaning that, but I would be genuinely shocked if she doesn't comment about the stuff we did. And when I say the stuff we did, I'm not just talking about me and XRP. I'm talking about all the amicus. I'm talking about Coinbase amici, Digital Chamber of Commerce amicus, Blockchain Association amici, where we all said to her, look, you have to say that the token itself is not a security, and you have to address secondary market sales. And so I think she will say something favorable to us because that's the law. And I think she'll follow the law that secondary market sales are not securities by themselves, that you have to there has to be a specific analysis as each transaction. I think she'll distinguish the token itself is just software code, and that sure, it can be marketed and packaged as ones, but that the token's not a security. I think that she'll comment about the inconsistencies of the SEC and their behavior. But ultimately, the SEC didn't prove their case. And so they can't win outright. And so the judge could say that a jury must decide whether or not XRP holders acquired XRP for investment reasons or non-investment reasons, or whether or not we were engaged in a common enterprise with Ripple, or whether or not we just, as Jeremy Hogan said, that it'd be more on the third factor, that we didn't have an expectation of profit derived from Ripple's efforts. And so those are the factual issues that could go to a jury. So we could get a situation where she says denied to the SEC summary judgment, denied to Ripple. Here's some general stuff to consider, secondary market sales, all this, and a jury must decide these issues. If you asked me to predict, I would tell you that I would bet money that he's never read it. That he doesn't, he's not even going to consider it. You know, the man in 2018 said that Ripple and Ethereum and the market needed clarity,
Yeah.
needed to give clear guidance. And then, today he says that it's been crystal clear since 1946. And so it's just insane. But all we can do is is fold our tent and go home and let America fall even further, or those in this industry who view this as part of the future financial system is to continue to fight. Here's what I can tell you to everyone that gets discouraged. Gary Gensler will not be there 3 years from now. He will not be SEC chairman in 3 years from now. I mean, whether the Democrats get reelected or Republicans come into office, he's just not going to be here 3 years from now.